Hello, everyone, and welcome back to Immigration and Jobs Talk Show. And we have another very interesting and very important session lined up for you. And before we have our guest in our episode today, I have this very important disclaimer, and that is by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, folks, thank you so much for joining us. We are streaming live on YouTube, LinkedIn, and on Facebook and on X. So, please feel free to comment wherever you've joined us, and maybe you would want to know more with regard to the topic. And it's super exciting that we are going to be joined by our very special guest who has been with us for over a year now. So please help me welcome him, none other than Attorney Chand Parvathaneni from SPB Law Firm, Dallas, Texas. Hi, Chand. So good to have you back. And this is our first episode this year. So here's wishing a wonderful 2025 ahead.
Yeah, thank you, Nipasa, and thank you for all the viewers watching, and a happy new year to all. This is my first show with you this year, and hopefully, we'll have a lot of engaging, knowledgeable sessions throughout this year.
I am already looking forward for all of them, and especially this one today because, we hear a lot of changes that are coming up, and yes, with regard to H-1B starting tomorrow, right? It's the 17th of January, so we are going to have a lot of updates, and also with those new changes, new rules, we are going to have new H-1B RFEs, site visits. So, would you like to tell us
Yes.
what people out there who are watching us right now, what can they expect from today's episode?
Sure. So what happened is under Biden's administration, Department of Homeland Security, DHS, they published a final rule in December. So December of last month, that's 2024, the final rule was published. And 30 days after the final rule is published, it takes into effect. So a lot of changes were codified and they were published. And the 30th day ends today. So tomorrow, starting tomorrow, which is January 17th, all these new rules kick into effect. And these rules are proposed to strengthen the H-1B program. And some of the rules are good, some of the rules are bad. But overall, I think I mean, one thing that's going to happen is things are going to change because now we have new rules. New rules have been codified, so a lot of things will change. And to give a perspective, what happened in 2020 is that in 2020 there was a lawsuit, and after the judgment, USCIS went and rescinded a couple of old memos. So these old memos talked about client letters, contracts, and a couple of other things. So USCIS, based on that lawsuit, based on the final outcome, these old memos were rescinded. And starting from 2020 June, what has happened is client letters were not mandatory, and contracts were not mandatory, and a few things were changed based on what has happened in 2020. So for the last 4 years, things were happening in one way. And because of the lawsuit, because what really happened in that lawsuit was USCIS failed in that lawsuit because they did not follow a proper procedure. So they have to follow procedures under Administrative Procedure Act, APA. And if they do it, the rule will be valid. And because these old memos did not follow those rules, they lost that lawsuit. So over the last couple of years, they went through the process. This time they did it properly. So they went through the APA process. They published the draft version of the final rule. They gave some time for public commenting. They went through all those comments, and then they published the final rule. So this time, so basically, whatever happened in 2020 with that lawsuit, I think they used all that experience to finalize this rule. And going forward, because a lot of things are codified, USCIS is required to follow these rules. And because of this, we can expect a lot of new RFEs. The reason is in the last 4 years, we did not see RFEs for contracts. We did not see RFEs for employer-employee relationship and client letters. Now, these kind of things will change. Now, again, contracts are mandatory. USCIS codified the definition of specialty occupation. They changed the definition of specialty occupation. They also codified some rules around site visits. Previously, site visits were done differently. Now, site visits are going to be done differently. So, all these rule changes are what are going to come into effect starting tomorrow, which is January 17th. USCIS is also publishing a new I-129 starting tomorrow. So starting tomorrow, a new I-129 has to be used, and this incorporates a couple of these final rule changes. And because of these new rule changes, USCIS can start looking at things differently, and based on that, they can start issuing new RFEs if the documentation does not conform to what is required as a part of this new regulations.
Right, right. So thank you so much for that overview, on what we can expect, especially that there are changes coming in starting tomorrow. And with those new changes, we are going to have new H-1B RFEs as well and different site visits as well. So thank you so much, Chand. And moving on, let's just hop in directly to our questions. So I have this first one with regard to specialty occupation. It's a new rules which are effective and the changes of getting an RFE, for H-1B applications, and what can employers do to get ready for all of that?
Sure. So, in terms of specialty occupation, so the rules have changed a little bit. So now what they're saying is it doesn't have to be a single degree. Multiple degrees that are related can be used. So, for example, if you say a job requires a computer background, for example, so a computer science degree might be the right field. Maybe software engineering also might be the right field. So, what USCIS is currently saying is yes, you can have multiple degrees required, but each of those degrees should somehow correlate with the job duties. So the job duties are going to be very, very important. And we probably will see increased number of RFEs for specialty occupation. The reason is now USCIS is emphasizing that a job must require a bachelor's degree. And not only that, that degree must be related to the job duties. So basically, what it means is the jobs, sometimes the jobs are a little bit broad, and the job duties are what is going to determine whether you require a bachelor's degree or not. And if the employer requires, say, a little bit wide degrees, for example, computer science, IT, and software engineering or software engineering, so USS is now not going to come back and say you are requiring multiple degrees. It doesn't have to be a specific specialty. It can be different specialties, but all of the specialties that the employer requires has to have a correlation with the job duties. So what that means is USCIS will look more closely whether the degree requirements are actually essential for performing the job duties. So they're going to look at the job duties, they're going to look at the requirements. And what it could mean is sometimes it could result probably in more RFEs. And so what employer has to do is you have to demonstrate that there is a direct connection between the job duties and the degree of the employee. So if all of those don't match, you might probably see more RFEs. We also probably will require more documentation because the employer will claim a particular degree is required, will claim that the job is complex, will claim that these are the normal industry standards, but based on the new rules that is probably not enough. And one of the things that the new rules are saying is the client requirements, the end client requirements. Sometimes when there is a third party worksite kind of an arrangement, the end client requirements also determine what whether the job is specialized or not, specialty occupation or not. So more than likely, we might require client letters where the client actually talks about the job requirements. So USCIS will also ask for documentation that the client, the degree that the client requires. So tomorrow, if there is a third party worksite kind of an arrangement, if there is no documentation from the client on whether a bachelor's degree in a specific field is required or not, tomorrow we might see risk of more RFAs, probably more denials. And not only that, some occupations I think will see more RFEs, and occupations like marketing, for example, marketing analyst, and also probably certain IT roles where the job zone. So every occupation, normally what we do is we go and check in ONET, Occupational Outlook Handbook. We see what is the degree requirement. And some of the jobs, like for example, computer systems engineer or web developer, if you go and look in ONET, the job zone, it is a zone 3 occupation, not a zone 4. Zone 4 is basically the normal requirement is a bachelor's degree. So more and more USS is going to look at the ONET requirements, and if a job is not in job zone or higher, more than likely we might see issues. And what that means is certain IT roles more than likely will start having issues. And the immediate thing I can think of is definitely computer systems engineers, web developers, and there are a couple of occupations. So all we have to do is go and look and own it and see what the job zone is. And if the job zone is three or anything below it, more than likely you'll have a problem. Four or above, more than likely you at least meet the initial test. So all of these things, what it means is employers can expect to see more and more specialty occupation RFEs, because we had a way of USCIS doing things all along. And into the future, the new rules talk a lot about specialty occupation. They have made a lot of changes about specialty occupation. They talk about end client requirements superseding the actual employer's requirements. So all of these things mean we'll see more RFEs on specialty occupation that we have not been seeing in the last 4 years. And employers have to be ready. And what that means is ensure your job descriptions are very detailed. So when you're filing a H-1B, if the employer does not give a proper job description, a very, very detailed and very, very elaborate job description, you will definitely see RFEs. So definitely try to give elaborate job descriptions. And in my opinion, if you're not giving at least a whole page of job description, a detailed job description, USCIS more than likely will come back at you. The reason is when you're filing a H-1B, you're filing a H-1B for 3 years. So you really have to tell USCIS what your employee is doing for the next 3 years. And if it is like a very, very small, short summary, USCIS probably will not be happy. So try to keep your job descriptions as detailed as possible. And not only that, you upfront you have to show clear evidence of job's complexity. So employers should be prepared to submit documentation demonstrating that the role is indeed a complex occupation. They can probably include expert opinions or industry standard documents upfront. Basically, the own it, the occupation outlook handbook, those documents should be part of the file upfront. And the petition should upfront establish that the job cannot be performed by somebody that at least does not have a bachelor's degree or above. So this is very important. And going forwards after Jan 17th, you also have to focus more on employees' qualifications. So if an employee does not have a degree in the right field, so if the employee has a civil engineering degree or a mechanical engineering degree or a commerce degree or a business degree, and employer is filing for a job in IT field, more than likely you'll see more and more RFEs, more and more denials going into the future. So documenting employees' qualifications, maybe their experience letters, maybe their prior experience, if their job is not in the relevant field, putting evaluations upfront. These are probably very, very important. If not, you'll see bad RFEs starting from Jan 17. And that being said, I think the rules are going into effect starting from tomorrow. So more than likely in about a month or so, we will have more data because we will see more RFAs based on the new regulations. And as regulations evolve, employers need to stay up for further clarifications or guidance from USCIS. More than likely, what I think will happen is down the line, USCIS probably will issue a memo or some kind of a guidance that will summarize how they will process cases based on these new regulations, and being proactive, being up to date with the guidances from USCIS, detailed job descriptions. That is the only way to reduce the likelihood of specialty occupation RFAs, because the new rule changes make a lot of changes for specialty occupation.
Well, thank you, Chand, for the detailed explanation and for highlighting the many changes that are coming up, and they're all going to come into effect from tomorrow itself. So, folks, just be ready, and especially employers out there, it's important that you take note of the points that Chand has clearly highlighted, and see that you follow, especially the detailed description for any job. And Chand, we also have viewers who have joined us with their questions. So I think I'll just say hi to K. Vishwanathan, Kavita, and I think we should also take up K's question quickly, just so we can move ahead.
Sure.
Yes. So blanket L1 petition being filed tomorrow. Can you confirm the timeline to get approval, and when can I get my visa interview and passport stamped?
Sure. The good thing is for L1s, no rules are changing from tomorrow. So the rules, whatever rules we have today, will stay even tomorrow. It's only the H-1B majorly that the rules are changing starting from tomorrow. So for L1, I mean, the company is going to file the case. The company has to wait for an approval. And for L1 cases, company can do it in premium. So if a case is urgent, normally the companies do it in premium. And the minute you get an approval for the case, the company gets the L1 approval. And you can, at that point of time is when you actually look for going up for stamping. And stamping, if you keep monitoring the dates, typically within a month, more than likely you will get dates. Even though it looks like you might not get a date, you have to keep on checking the website. So once the case is approved, probably within a month, more than likely you can go for stamping. And at least L1 at this point of time, we're not seeing any proposals to change the rules. So at least we don't think anything is going to change for L1s, and the rules that are currently there probably are going to stay at least for the next couple of months.
Okay, thank you so much, Chand, for updating us. And I hope, Kay, that you got your answer to this. And if you have more questions, please feel free to keep commenting. And I think we would love you to join us on call. Anybody out there watching us, if you have any questions for Chand directly, you can join him and me here on call by dialing this number on the screen that is available. So the number is 425-436-6335, and the access code is 988888. So please feel free to join, and yes, we will be hearing from you. And Kavita, please stay with us. We are going to take up your question very soon. But Chand, my next question to you is, what do you think will USCIS check during site visits, under the new rules, and how can employers follow the new rules to avoid having their applications denied or cancelled?
Sure. So one of the things that majorly changed and was codified as a part of the new rules starting tomorrow is the site visits. So we had the site visits since almost 2010. The site visits are conducted by the FDNS officers, and as a part of the site visit, normally what they do is they come unannounced. They come to the employer, they come to the work site, sometimes they come to the home and start asking questions. And the rules that we had so far, all along till today, end of today, January 16th, is that the FDNS site visits, when the officer comes, participation in an FDNS site visit is voluntary. So what that means is we do recommend the employers to participate. We do recommend employers to give as much information as possible. That being said, if an employer does not participate in an FDNS site visit, if in the current rules, if the employer or the employee say that they don't want to participate in the site visit, normally what happens is the site visit ends. And if USCIS is not satisfied with the answers, they normally issue a notice. And as a part of the notice, they ask for answers, but at least they don't revoke the cases, they don't deny the cases. Uh, if employer or an employee say that they don't want to participate in a site visit, and that was the rule all along. Site visit participation in site visits is voluntary. Starting tomorrow, Jan 17th, what has changed is, as a part of the new rules that were published in December last month, that will be in effect from tomorrow, site visit participation in site visits is now compulsory. It has been codified as a part of the new rules. It has been codified. So what that means is, if there is non-compliance, if they don't cooperate with the officers, if they don't participate in the site visits, the cases might be denied. The cases might be revoked. How exactly USCIS will do that, we don't know yet, but they now have that authority based on these new regulations. They can do it, and we think that that is what will happen. Now, the things like what USCIS will check during site visits. So typically, what happens is they verify the employment and the job duties. So the USCIS officer, they will come to the company or to wherever the employee is working. Maybe it's a client location. Sometimes they come to the client locations. Sometimes they come to their home. They go to their apartments. They go to their homes. So this is something what has been happening, and starting from tomorrow, it is actually codified. And what they want to check is, so typically what officers want to check is the employee actually working at that location? Is the employee actually working on the job duties that align with those described in the petition? They will check whether the employee's role matches the description of a specialty occupation, and if the required skills and educational qualifications are actually being applied to the job. This is something what they check. They also look at employer-employee relationship. They want to make sure the company is paying the employees. They want to make sure employees being paid the right wage. They want to make sure the employees' work schedule, the work conditions, everything is appropriate. And uh, they also look at the work location. One of the things they want to make sure is the officers, they want to make sure the LCA is being complied with. And what that means is the work location. They should work as per the terms of the LCA, in the right occupation, right work location, right salary. So all of these things are something what USCIS wants to verify, and that is what they will do as a part of these site visits. How they do it? They simply come, they show up unannounced, they make sure the employee is actually working at that location, the employee is actually uh, available at that work site, the employee is actually getting paid. They ask for pay statements, they ask for various documents, and they actually make sure the company is actually operating. I mean, if a company is just filing a case and not really operating at that location, they have a problem. So these are the kind of things that they will do. And why this could be a problem is sometimes employees are working at the client location. The clients may or may not be happy with the USCIS officer coming for a site visit. So now the employer and the employee, they're also dependent on the client actually letting the officer verify the information. If the client says, no, we will not let you come into our work site, tomorrow the H-1B, it could be revoked, it could run into an issue. So these are the kind of things that could be an issue, because in the past, if the end client said, no, we don't want to participate, we don't want you in our office, at least we didn't see direct denials, direct revocations. Now probably more than likely we might see issues. And how do employers do things in the future? So in the past, some employers, because it was voluntary, they simply said they don't want to participate. In the future, there is no choice. So what that means is employers have to keep accurate and consistent documentation. So employers should be readily have that information available. What is the job description? What is the job that is being assigned to the employee on a daily basis? What is the work location? What are the terms of employment, as in salary and so on? They need to maintain accurate records, because USS officer might ask for pay statements, and USS officer is not going to be giving them a lot of time. So always employers should have a process in place to give this information to the USCIS officer. And employers should constantly look and see if the duties are changing, because sometimes assignments change one project to another project. At every stage, they have to make sure job duties match. If there is a change, a material change in job duties, employers must file a new case, a new amendment case. So this is very important. And not only that, employees also, every employee should have a copy of their LCA. And if an employer is not giving a copy of the LCA, that is illegal. Every employer, they don't have a choice. They have to give the copy of the LCA to the employees. So every employee should have that LCA in their hand. They should look at the data in the LCA, the salary, the work location, the occupation. And if employer is making them do something or not paying them on time, make sure you point it out to the employer. Make sure you document it. Maybe send an email, or you call them. Make sure you document how you're contacting your employer to notify them of any violations in LCA. This is very important, because when you have a site visit, you have to make sure your LCA is completely 100% complied with. If not, tomorrow your H-1B is jeopardized. And make sure your employer is retaining control over you. They're paying you, they're in contact with you, they're helping you with any employment problems. If not, there is not proper employer-employee relationship. Make sure that is being done. And complying with the wage requirements, that is the number one thing for any company filing H-1B. If a company is filing H-1B, they better pay the employees as required. If not, the employer is going to have definitely have a problem. And sometimes we see employees being penalized because employees are not getting paid. They try to do a transfer because the employer is not a good employer. And now when the transfer is being done, unfortunately, USCIS is punishing the employees. Even if the employer is not paying, employees are getting punished. So it is highly important that if an employee is not getting paid, keep documentation, keep proofs, contact your employer, let them know in writing that you're not getting paid. And if an employer is benching you, benching is illegal. Benching is illegal, not paying you on time is illegal. So this is very important. And if you're working with an employer that is doing these kind of things, immediately move away from those employers, because tomorrow your H-1B will be jeopardized. Because we had cases where we had a case and employer is not paying somebody. We notify USCIS, we show proof that employer is not paying. And then in spite of that, employer is having an issue, because USCIS will come and argue employee is not maintaining status, even if the employer is not paying the employee on time. So be very, very careful. Don't work for with any employers who are benching you or not paying you on time. And number one thing is everybody should be prepared for a site visit, because going into the future, the new regulations give a lot of power to site visits. And what that means is every employer that is filing a case, you should be prepared for a site visit. If you feel you cannot handle a site visit, do not file the H-1B. So, and from an employee perspective, be prepared that you will have a site visit. And what that means is be prepared, because if you don't have a site visit, it is good. But if you have a site visit, at least you as an employee should be confident that everything is legit. Because if something is going wrong and the employer is not doing things properly, you should not stay with that employer. Look for another employer. Okay. So always do an internal audit. The employers should do an internal audit, and even the employees, you as an employee should always look at things, look at your LCA, demand the LCA from the employers. If the employer is not giving it to you, they have to give it to you. And if not, you always have that, you should always be able to complain to USCIS. You should be able to tell USCIS if an employer is not giving you a copy of the LCA. If LCA cannot be hidden from you. You should know what the LCA says. Okay, so that is very, very important. And everybody, the employer and the employee, make sure you're complying with the terms of LCA. And if not, you'll have a problem with the site visit. At the time of site visit, if you're getting paid like you're supposed to, if you're working from the location you're supposed to, don't worry about anything. Nothing is going to happen. Okay. So all that needs to happen is, if you're working as per the terms of the LCA, you're getting paid as per the terms of the LCA. Site visits are not problematic at all. Site visits are problematic only if you're not getting paid and if you're not working as per the terms of the LCA. So the bottom line is, your LCA, look at your LCA, you're working, you're getting paid as per the terms of the LCA, the site visits will not impact you at all. It's only if you're being benched, that's when the site visits will cause a problem. So the summary is, there should not be benching. If there is benching, try not to stay with that employer.
Thank you so much, Chand. I think those were great things to keep in mind. And thank you so much, really, for the detailed explanation. Now let's head on to my next question, which is about the I-129. So there are changes that are happening to it too, and the effects of the chances of getting an RFE. What common mistakes should employers and workers avoid? Just in short, if you could just name a few.
Okay. So the old I-129. Today is the last day for USCIS to receive the old I-129. Starting tomorrow, that I-129 is not even published yet. It's going to be published tomorrow. It will be available in USCIS website tomorrow. And starting tomorrow, USCIS will only accept the new I-129, the new edition I-129 that will be made available very soon. And in this new I-129, they made a couple of changes. And the reason they made a couple of changes is because the new regulations, the final rules starting from January 17th, they are looking at some changes, looking at some new things. And to correspond and to conform to the new final rules, what USCIS has done is they've changed the I-129. They published a preview version, and in the preview version, they made some changes. And the major change that we see USCIS has made is, now in every I-129, they're very, very clearly asking about the third party work site. So if somebody is assigned to a client, upfront in I-129, they've added some data points where they're collecting information about the work site. They're specifically asking if it is a third party work site. And if it is a third party work site, they're upfront asking who's the entity that is maintaining or managing that work site. So what that means is, tomorrow when USCIS officers are looking at the I-129s, upfront on the I-129, they will look at cases where somebody has a third party work site, and they will look at cases where there is no third party work site, because the rules are different. And what to me that means is, third party worksite kind of cases probably will have more scrutiny, will have more burden. And the reason for that is the new rules, they clearly talk about client requirements. So the officers, I think, they need to analyze cases differently. So whenever there is a third party worksite kind of a case, an end client, vendor, these kind of cases, they have to look at who the end client is, what are the requirements of an end client, and then based on that, they have to process the I-129s. So from a USCIS perspective, things have become a little bit more complex, because now they have to look at all these things. But because of the new rules, that is what they will be doing. And from an adjudication perspective, from an employer perspective, from an employee perspective, you have to be ready. And you have to be ready with client letters. You have to be ready with vendor letters, because USCIS is going to demand those documents, because they need to know what the client requirements are. They need to know that it's indeed that client. So bottom line is, there will be more scrutiny on the I-129 because of these changes that are happening to the form I-129 starting from tomorrow, because of these additional questions about the third party work site, third party client name, etc. on the I-129. going forwards. So definitely, if you don't have client letters, your cases probably more than likely will have increased scrutiny. You'll have challenges. So for every case that has a third party worksite, somebody's working for an end client, we have been recommending, starting from tomorrow, you have to go back to your end clients, you have to ask them for documentation about confirming the job assignment, confirming the educational requirements, and so on. And if not, you will see more challenges. And from an operational perspective, you need to provide more supporting documents we didn't have to provide in the last 4 years, are now having to be provided. So H-1B filings probably for third-party work site now will take a little bit more longer, because now you have to wait until you get all the documents to file a H-1B. If you file without these documents, more than likely you'll get an RFE. And what we are suggesting is, until you have these documents, do not file the case. Even if it takes time, it takes time. But you rather provide all these documents thoroughly upfront and file the case, rather than you get a very, very big RFE and then realize that you cannot solve the RFE. So things regarding the end client assignments, I think, are what needs to be attached. And for those employees who are working for full time companies, more than likely this is not a challenge, because you don't have a third party work site. Anybody with full time employment, on the I-129 form, we don't see a lot of changes. It is only with third party work site kind of cases, that is the additional information that got added in the new form I-129. And some mistakes to avoid on form I-129. This is more for the employer, because employer is the one that is doing I-129. The main thing is, employer should make sure they provide everything that is required on the form I-129. Do not accidentally miss any information. Things like wage details, employee qualifications. Make sure everything is accurate, and demonstrate specialty occupation upfront. Demonstrate specialty occupation, okay? Because there is a way the burden of proof has to be proven. Make sure it is done as per the new regulations, and also complete documentation of work locations. So the new form adds multiple work locations in the form itself. So every employer make should make sure the complete documentation of work locations is done on the I-129 form itself. And what that means is, some people are working from client side, from their home, and so on. They have multiple locations. So all of this has to be a part of your I-129 upfront. Any incomplete or unclear information about all the work locations will be an RFE. So if you have multiple work locations, make sure everything is put upfront in the I-129 itself. So not properly putting the worksite information, the multiple worksite information as a part of your I-129 is not only going to be a problem with the initial filing, but even when there is a site visit, if it is not listed on the I-129 and you're working from home, it could be an issue. So always make sure the I-129 is thorough with the worksite information. If you're working from multiple locations, make sure it is documented. And so doing these things, making sure the form is thorough, I think things will be easier. That being said, third party worksite kind of cases, they have to ensure that the new I-129 form, the new changes are appropriately filled out, and the supporting documentation is not only accurate, consistent, and it should also be complete. And doing so, I think, will avoid the new kind of RFEs.
Well, thank you so much, Chand. And yes, so the I-129 form is also going to be a new one starting tomorrow. So, do you think that it's going to affect people who have already filed their I-129 up till today? Will they also have to?
Up till today, they're fine. Yeah, up till today, they're fine. So any H-1B application that USCIS gets until today, it's still going with the old form. And those petitions, they should not run into an issue with the new rules. The new rules will be in effect from tomorrow. So any filings being done from tomorrow, where USCIS receives the file starting from tomorrow, those are the ones that have to make sure all these new rules are confirmed with, and make sure all the supporting documentation is appropriately attached. Until today, it's still the old rules, so still the old forms. So as long as the burden of proof as per the old rules are met, they should be fine.
Okay, that is awesome. Because we've had so many viewers who've been asking if theirs is going to be affected. I mean, these new rules are going to affect them or not. So thank you so much for the confirmation. And we have Kay again with some more questions. I think we should quickly just address to them. So hi back again at UK.
Sure.
So we have L2 processing is after I get my L1, he says. Will L2 qualify for Dropbox? But they have they never been to a face to face? If no, when can they visit an interview in the next 3 to 6 months, as would not like them to get rejected? L1, I have team.
So anytime after
Okay.
yeah. So L2 is basically the dependent of L1. So whenever the principal L1 employee gets the visa processing done, immediately after that, at any point of time while the L1 is still valid, the L2 dependents can go for stamping. So L2 dependents, whenever they're ready, they can go for stamping once the L1, the primary employee, gets his visa stamping done. And they will have to go for an interview because looks like it is the first time they're going for stamping. And based on the current rules, they will not have an interview waiver. They just have to fill up the DS 160, book an appointment, and then go for an in person interview.
Okay. And he was also saying L1 have team at NJ, New Jersey, but while I manage that team, I have too much of travel to meet clients. Can I still live? I'm in central US for ease of traveling. What has social media IDs impact in DS 160 and interview?
Yeah. So in terms of the work locations and traveling and so on, so as a part of the L1 filing, the employer will document what is the nature of the work, what kind of work is being done, what kind of travel is being done, uh, what are the work locations, and so on. So from an employee perspective, he has to make sure that he coordinates with his employer and works as per the terms of the I-129. So for L1, we don't have an I-129. So as per the terms of I-129 in general, they have to make sure they're complying with the regulations. And in terms of what is the other question other than travel? So traveling is
Social
probably what
media.
he has to coordinate with his employer. I think there was another question
Yes, he
after
was asking about
traveling.
social media. What has social media's IDs
Oh, social
in
media.
this?
Yeah, yeah. Yeah. So in DS 160, for everybody, they ask for social media. And what is happening is the computer systems that Department of State uses, USCIS uses, they're very, very powerful. And what they do is they do a lot of data mining. They check for a lot of stuff because it is in the interest of national security. So they do want to make sure the social media sometimes is checked. And the reason they do that for all DS 160 applications is because they want to make sure for all the people that are trying to get a visa, whatever their intent is really their intent. And sometimes they use social media. Sometimes they go and check to make sure that's the right intent because they want to make sure somebody is not coming into US saying they want to come to US for something on DS 160, but their intention is different. So for that reason, they ask for social media, and they definitely do check. I don't know how deep they check for each and everybody, but based on some red flags, they do keep checking it.
Okay, okay, Chand, thank you so much. And I think, Kay, you've gotten your answer. So thank you so much for participating. Please join us on call. We would love you to join. You can call us on this number 425-436-6335, and the access code is 988-888. So once you're in, just speak with us and we will be able to hear you. And this goes out to Kavita and also to we also have Namrata. So please join us on call. It would be really nice to have you. All right, folks. So we will quickly take a short break, but before that, I also want to tell you that you can even contact Attorney Chand Parvathaneni, and you can do so by calling him up, or you can even email him, and even visit his website, that is spblawfirm.com. And to call him up, you can call him on his number, and the details are on the screen, please. His phone number is 817-523-8247, and you can email Chand about yourself, your case, especially K, since you have been asking a lot of questions. I'm sure your case is going to be very different. You can even email Attorney Chand Pravathaneni at his email address is law@spblawfirm.com. And definitely don't forget to visit www.spblawfirm.com to get to know more about Attorney Chand Pravathaneni and Sin. Yes, an SPB law firm. So, yes, thank you so much. We'll take a short break and going to be right back. So, stay tuned on Immigration and Jobs Talk Show. Welcome back, everyone, to Immigration and Jobs Talk Show. And today we are having none other than the special guest, Attorney Chand Parvathaneni from SPB Law Firm, Dallas, Texas. And we have been discussing about the new RFEs that are going to come up and site visits, especially starting with the new rules, which is starting tomorrow, 17th of January, 2025. So, Chand, before this, we were speaking about so many things, the new updates, of course, and we even took up K. Vishwanathan's questions, and I do hope that K has gotten his answers. And we will be taking up the rest of the questions also, folks out there. Please stay with us. But my next question to you, Chand, is also about remote working, since it is the trend now. And you were speaking about, the systems in US being so strong that they're able to locate where their employers are working. So, for H-1B workers doing remote jobs or working in different locations, what extra paperwork will be needed to stay compliant with the new rules?
So remote work is completely legitimate, and when somebody is working remotely, either from their home or from their apartment, it's completely legitimate. And normally, the kind of cases that we see are 100% remote, where somebody is working completely from their home, or remote where sometimes they have to go to their client location, sometimes to their employer location, sometimes at their home, a mix and match of locations. So from a regulation standpoint, both are allowed. The only thing is, it has to be done properly, and the way it has to be done is in the LCA. So whenever a company is filing for an LCA, they have to make sure they put all these work locations, multiple work locations, in the LCA, and they have to determine the salary at each location and use that LCA for H-1B filing. And when the H-1B is filed in the I-129, so if the employee is working remotely and also from the client location, for example, two locations, they put it. If the employee is working 100% remotely from their home, they put it. But the bottom line is it has to be filed in the LCA, and then it is allowed.
Okay. Okay, so it's very important to be filed in the LCA. And thank you so much, Chand, for the detailed explanation again. And yes, we do have more questions. So I will quickly take up this next one. This is also about site inspections, the site visits. So how will the increased site inspections or site visits affect the third party work sites and even the staffing companies? So what can they do now to prepare for all these lately, I mean, the new rules that have come up and the extra site visits or inspections that are going to happen?
The site visits for third party work sites, that is going to be challenging, and that is what I think might impact a lot of people. The reason is, some clients, they don't have any problem. They will work with the USS officers, they will verify things and move ahead. They will let them come into the work site. And the reason is, the contractor who's the H-1B employee, they're not the third party company employees. So that is why sometimes they do let the officers come in. Sometimes they say, no, we will not let you in because so and so is not our employee. And in the current rules, if the client is not cooperating with the USCIS, they're not validating the information, there is a possibility that that H-1B could run into an issue. So, so how do you prepare? So, in order to prepare, I think every employee who's working at a client location, they should at least let their client know that as a part of the H-1B process, a site visit could happen, and be prepared. And if possible, try to get a contact in case there's a site visit. Who do you contact at the client location? So if the employer tomorrow finds out that there is a site visit, or USCIS is trying to do a site visit, because USCIS will definitely notify the employer at that point of time. They, at least if there is a contact with the client that they could work with, at least they can immediately let that client contact know, so that client contact could coordinate with USCIS on answering their questions. So the site visits could happen at the client location, and the companies have to be prepared for that. And part of it is convincing the client that, hey, this is a part of the process, please do cooperate with them, because if they don't cooperate, it could jeopardize your H1. And some clients don't have a problem, some clients could have a problem. And if it looks like it's a client that you could have a problem, probably you have to look long term in finding another project, because if a client for sure is not going to cooperate with USCIS and will not validate anything, Tomorrow, we don't know what USCIS will do. Maybe in the next couple of months, we'll have more data. But in the current rules, the current rules that came out last month, if somebody is not cooperating, somebody is not participating in a site visit, and that includes the third party client locations, it could jeopardize the H-1B.
All right, Chand, and thank you so much again for those updates. So, this is what we heard after. I think these things came up right after the elections, right? These new rules are going to set in. So, but then Trump is only coming to the office on the 20th of January. So, you mean there was no real connection with Trump? I mean, these new changes, with or without Trump hitting, or whoever would have hit the office, these changes were supposed to happen, right?
So all these changes are actually by Biden
Mhm.
administration, and the way the rules were put in, it's not really like a quick process because the Biden's administration was working for almost a year and a half, 2 years on these things because a long time back these rules were actually published in the draft mode. So this was happening for a long time, and actually the new rules, some rules are actually very good, some rules are bad, but some rules are very good. So it's a mix and match. It's a mix of good news, mix of bad news for H1Bs. So it's again not something that the Trump administration or the Trump team has done. It is what Biden's administration has done, and they've done it after following the proper procedure. So they're actually working on this whole changes for the last, I would say, 2 years at least, because the step number one was publishing the draft. So these rule changes, they published the draft almost 2 years back, a year and a half back, and they took comments. And the only reason I think they published it in December is if they publish the rules and they get active, which is effective before President Trump takes his office. So President Trump is taking his office on January 20th, and if a rule becomes active before January 20th, the new administration cannot immediately change it. It is not easy for the new administration to immediately scrap the rules like in one day. It is going to take them a lot of time. So Biden's administration, I think, probably strategically finalized the rule last month, so it will get into effect before President Trump takes his office. So tomorrow, if the rule is getting active, the new administration, they cannot change the rule that quickly. They can definitely change it, but they have to follow a big process, a big APA process. So if they really want to change something, it is definitely going to take a little bit of time.
Okay.
So for those reasons, it's not the Trump administration at all. It is Biden's administration that finalized these rules,
Okay.
and they are the ones that are making sure these rules are active starting tomorrow.
Okay, okay. Thank you so much, Chant, for taking that up. And we also hear that the updated cap gap rule for F1 students, which is moving who are moving to H-1B status, match with the new compliance rules. Do you think these new rules are going to reduce the RFEs for these students?
So the cap gap rules. So that is like one of the good things that happened in the new rule. So the cap gap, it's not going to reduce any RFEs, but what's going to happen is, so this is what cap gap says. If somebody gets picked up in a lottery and they're about to have their EAD card expire, so say they got picked up in the lottery in March, and in June their EAD card is expiring. So what cap gap used to previously say is, if somebody files a H-1B for you, even if your EAD card expires, even if your work authorization expires, you can still continue to work until October 1st, September 30th. That is what the old rule said. So pretty much for a few months, even without an EAD card, they were able to get a automatic EAD card extension till September 30th. That was what the old rule said. So the new rule, which is a better rule, what now it says is, if you have a H-1B filed by a company and your EAD card expires after filing the H-1B, you don't have to stop working. You can continue to work even after October 1st, all the way until April 1st. So it's like another 6 months of additional time. And this is very good news because sometimes USCIS does not adjudicate the cases by October 1st. So a lot of people, because cap gap was a good thing, but it expired starting from October 1st, they had to stop employment. So in the new rules, because they got a little bit more time on cap gap, a lot of people on OPT whose EAD cards are expiring after H-1B is filed, they can continue to work even if the H-1B is still pending even after October 1st. So all it is doing is it is helping people who are students whose EAD card is expiring to continue to work even after October 1st if their H-1B is still in process. So it's this is one of those things that is really going to help a lot of students
Yes.
starting from this year.
Yes, yes. One good news. Yes. Thank you so much, Chand, for highlighting. And Chand, we also have a couple more questions, even from Facebook groups, that we would like to take up. So without further ado, I think we should take them up. So, Control, if you can display them, please. This first one is: Hi, all. Is it worth doing day one CPT if H1B is not picked in all three attempts?
So I think rather than say is it worth, first of all we have to look at the legality. So is it legal? CPT is legal, for example. So if H1B is not selected in the lottery and their OPT is expiring, so there are two choices: either somebody leaves the country or change their status to change their status or do something that will maintain their status in US. So what people do is, if their OPT card is expiring and their H1B is not selected in the lottery, they have to change to a different status or maintain their F1. So if somebody is married, maybe they can look at H4 option or some other status option. If not, what they can do is they can continue their studies because somebody has F1 and before their F1 status expires, because they're not selected in the lottery, they can continue their F1. So what that means is they have to maintain status, they have to enroll in a college, and they have to strictly follow the rules of F1. And the rules of F1 require them to go to college, attend classes full time, pay the tuition, and progress towards getting a degree. So they can't fail classes. They have to progress getting a degree. So that is what they're supposed to do. And as a part of it, if that school requires CPT, because CPT has its own very, very strict rules. So as a part of it, if the school requires CPT, definitely they can do CPT. But make sure the CPT regulations are all met. So there is nothing wrong in doing a legitimate CPT, but the bottom line is they have to maintain F1 status, which means they have to do everything that is required as a part of F1, which is attending classes, successfully trying to progress towards a degree, and so on. Now the question is it worth it? F1 is a very expensive program because again they have to pay tuition, they have to go to college, they have to do a lot of things. And in their career plan, if getting that second degree is worth it, yes, I would say it is not a problem. Continue to do your F1 program. Make sure you attend classes, and as a part of it, if your school requires CPT, it is valid. Document everything that you're doing because tomorrow, if USCIS asks, you have everything to show that you're maintaining status in a legitimate way.
All right. Thank you so much, Chand, for taking that up. Now, Control, if you can display the next question, please. So this is also on Facebook. Let's Hello, all. I need your guidance regarding my travel plans. I'm planning to visit India in February, and I'll need to go for my H-1B visa stamping during this trip. Considering the new administration transition, could it be advisable to travel during this period? And if yes, what steps should I take to ensure everything goes smoothly? I would greatly appreciate your insights and suggestions. Thank you.
Sure. So during last Trump's administration, President Trump's administration in 2017, when he just took office, what happened was immediately in a few days there was a travel ban, and this travel ban was limited to a few countries. So I think the whole reason, like a lot of people are confused, is there going to be another travel ban? I don't think there'll be another travel ban on H-1B in the next few months. So I definitely don't think that is going to happen. But because there is this rumor that there could be a travel ban, because last time there was a travel ban, I think people are worried. I don't think there'll be a travel ban. But again, you have enough time because it's February and President Trump is going to be in office next week. So if there is really some kind of a ban, you'll know about it. But I definitely don't think there is any kind of a travel ban, and at some point of time you do have to travel. So I don't think that you should change your plans. Just monitor what's happening in the next 10-15 days, and just take your decision. And I would not worry about it, because as long as you have a legitimate job and your company is supporting you because they want you to work for them, go for stamping. I don't think you'll have any problem. And more than likely, because you're going from US to India, you already had a US visa in the past, which means you actually get Dropbox. You don't have to go for an interview. So more than likely, your process will be a little bit more faster and smoother. So I don't think you should worry about traveling to India in February, unless there is some kind of a travel ban in the next few days. which I don't think is going to happen. I don't think there'll be any kind of a travel ban for H-1B employees.
Okay. Thank you so much, Chant, for that. And we also had Kay with another question, but Kay, I really suggest you to join us on call. So yes, you could ask the question yourself to Attorney Chand Parvathaneni. And once again, I can repeat the number 425-436-6335 since you're in NJ, or sorry, in Texas, but you can call us, and the access code is 988-888. Please feel free to join us. And Chand, we still have, maybe we can take up one more before we go. So if you can display that, please, control. Hello, immediately attention is required, it says, and I'm traveling to India on January 31st for my H-1B visa stamping, another travel. I submitted my DS 160 form in July 2024, but I recently realized I mistakenly updated my employment information in that section. To provide some content, I graduated in December 22. My first job started in February 23 and lasted for 1 month. After that, I got research work at my university until the end of May. Afterwards, I started another job in June 23 and still work here. I just updated the current employment section. Do I need to update my work? Additionally, could you advise me on how to change my DS 160?
So if the DS-160 is already submitted, more than likely they cannot make any edits. But what they can do at that point of time is email the support and let them know so it is documented. And I think if it is not submitted yet, they can make an edit. But if it is not letting you edit, just email the support line.
Okay. Thank you so much, Chand, for taking this up as well. And I think, yeah, we should take up Kay's question since I was really waiting for you to join us, Kay. I mean, but yeah, let's just take it up. So he says, "Hey, thank you. I love Chan's respond and attitude than the other podcasts I had in the past 4 months on your channel." Well, thank you so much, Kay. That really means a lot. And thank you for the compliments for Chand as well. And thank you for taking it up. I appreciate. And sorry, he says, but he has one last question. And he's saying, under L1A managerial expertise, I am employed in NJ, but can I stay in Texas and get caught in W2 or IRS?
I mean, again, in terms of the pay statements and IRS reporting, always make sure that your pay statements reflect wherever you're working from, because the taxes will be different. If you're working in Texas, for example, you don't have to pay state taxes. If you're working in New Jersey, you have to pay New Jersey taxes. So, so if your payroll is not reflecting the actual place you're working from, tomorrow you're probably not paying the right taxes. So tomorrow IRS can come back and claim that there is some tax fraud happening. So to avoid it, always make sure your employer, they report to USCIS where exactly you're working from, and on your side too, from your perspective too, wherever you're working from, your payroll should reflect that, because tomorrow you don't want IRS down the line to come back and say you didn't pay these taxes properly, because the state you live in will determine your state taxes. So sometimes the taxes will be different. How much money you owe the state governments will be different. So for this reason, your payroll should accurately reflect wherever you're actually physically working from, and doing so you should not have a problem. And your company can always make sure they notify USCIS appropriately by doing the right I-129 filing. So that way they report wherever you're supposed to be at, and then they pay you wherever you are at. So that way there is no problem with USCIS nor with IRS down the line. Because you are under L1A, more than likely you will qualify for a green card very soon. So you'll have to file for I-485 also very soon. Because the typical transition is L1A, they do I-140 filing under EB1 category, and you probably will be able to get a green card soon. But what that also means is you're doing an I-485 filing. So you don't want any of these steps to be jeopardized, because when you do your I-485 filing, you'll be submitting your tax returns and a whole bunch of other documents. So just make sure everything is aligned. If not, at this point of time, the company can fix it, make sure the I-129 filing is appropriate. But definitely the good thing is you are coming under L1A, which means as soon as you come, the company should be able to pursue the I-140 under EB1C category, and you should be eligible for a green card in a lot faster way than the other EB categories.
Well, thank you so much. And I think with that, we took up all the questions from Kay. And we're really happy that, Chant, you covered so much on this topic we had the discussion on today. And that is not I mean, with the new rules that are starting tomorrow, January 17th, what new RFEs can we have, and about these different site visits as well. So thank you so much. And maybe last but not the least, if you can wrap up with anything more or a few more points to keep in mind, just to highlight to all our audience out there, it would be great, Chand.
Sure. I think the big thing is, I think in H-1B world, there are two things. One, a full-time job where you work for the same company, there's no end client. And the other model where you're working for one employer, but there is actually an end client. So the full-time guys, I think all of you make sure that you have the right LCA. Make sure you compare your LCA to whatever you're supposed to do at your job. And for the third-party client worksite kind of folks, make sure you have the LCA and you're complying with the LCA. And not only that, make sure you get the client letters because you will need the client letters for your extensions, for your visa stampings, and so on. And that is very important. Not only that, let your client know. I mean, some you need to have a client contact in case there's a site visit. Be prepared for a site visit. If there is a site visit, you need to have a proper protocol in place. So you're not like running around at that point of time. Site visits are not bad. All they want to check is you're getting paid. It's actually going to protect employees because they want to make sure employees are getting paid. Employees are not being exploited. So in a way, site visits are not bad. Only thing is you need to have a protocol where you're not worried at that last minute. Be prepared. All they're going to ask you is your pay stubs, your job duties, and confirm that you're actually working at that location. So it's nothing huge. It's just that you confirming that everything is right and you're getting paid the right amounts. So doing so, I think you will be prepared for site visits, and we will have more data in the next couple of months. But again, as long as you're working and getting paid, the companies are paying you. Nobody should have any issue at all.
That is great news. So all we have to do is follow the law and do everything correctly, have all the documents right, all the information right in proper details. And I think, yes, nothing is going to um, be too bad for us, right, Chand? So with that, I think that is a wrap
That is
for
that is
yeah,
correct.
for
Yeah.
today's episode. But folks, thank you so much for joining, and you can call Attorney Chand and his number as well to contact him further on your case. His number is 817-523-8247, and you can email Chand at law@spblawfirm.com, and go visit www.spblawfirm.com to get to know more about Attorney Chand Parvathaneni. And thank you so much, Chance, once again. It was a real insightful session. You have a great day ahead.
Thank you so much,
And
Nipasa.
folks, if you still have questions, keep commenting because we will make sure to address to them and even take it to our attorneys who can give you proper answers to each of your questions. So please feel free to keep commenting even after the stream has ended. And you can even email me or contact me. And my phone number is 408-335-6444. You can even WhatsApp me in the same number. And my email address is nipa@staffingly.com. So thank you so much. Y'all out there have a great day ahead. And don't go anywhere. Stay tuned on Immigration and Jobs Talk Show because we have another webinar lined up with host Sam and our guest attorney, Uma Mantravadi. So stay tuned. Bye bye for now.